Hello, everybody. This is an important case update for all the landlords out there. We represent a lot of investors that have properties, whether it's a one single family home or a bunch of apartments, commercial properties, and that kind of a thing. Today is a cautionary warning. We just had a victory in a case. I can't give exactly the details, but it was a civil rights complaint. But what's important to you as an investor and as an owner is what came out of that report. And so the basic allegation was landlord had discriminated against tenant, right, for being in a protected class and was not taking care of their properties. So we had quite a bit of evidence, went back and forth. That's how that process works. And then understand that these tenants will maybe gang up on you and try to think that they're helping each other out, basically, is what I want to say. And so as part of the investigation, Civil Rights Commission went around into this apartment complex and interviewed a bunch of the tenants and said, does the landlord fix your property, but not this other person who's in a protected class? And allegedly, all the tenants said, yeah, right. None of us get our property taken care of either. The landlord is terrible. The landlord doesn't fix our property. So no discrimination on that basis, but the underlying story is, wait a minute, all the tenants say that the landlord is not taking care of their property. Now, this is a client that's been in the business for decades, never had any legal troubles with any of his tenants, suddenly has a little discrimination investigation from the Civil Rights Commission, and all of his tenants say he does a terrible job taking care of them. I don't believe it. I don't believe it for a second, and probably you don't either. But if you were in court and you were litigating a case and the matter comes before the judge or the jury, and you have a whole bunch of tenants come in and say, we all get bad service from the landlord. The landlord doesn't ever fix our properties. We've got all these leaks and this and that, whatever it is, right? That now you're having to, as a landlord defense counsel, you're having to flip your script and kind of prove that you're a good landlord, you're always taking care of things, and you're fighting all these other tenant complaints at the same time. So what do I want to have you take away from this? Number one, witnesses are unreliable. Number two, they might gang up on you, right? Mob mentality, so to speak. This is very common in the world today that we see, and people might gang up on you in social media in this kind of a case or whatever. And so you got to be very careful as a landlord, your actions and your messaging. And even though you're not doing anything wrong and you are being responsive, you need to document that. Document everything you're doing with your tenants. Every interaction needs to be documented so you can prove you got a call for a repair on one day, you fixed it the next day, the work ticket went out the next day, materials were ordered the next day, right? Whatever it is, so you can have a nice, crisp timeline to prove your case, because we had a lot of very good evidence in our case proving that we weren't discriminating against this person for any reason whatsoever, let alone making repairs. But that's where the litigation started to go, was whether or not the landlord was making repairs to his property or not. And I want to just put you on notice about that. It's a very important learning lesson for all the great landlords out there that are providing housing for the population. Almost a third of Indiana is a tenant-based, rental-based economy, and we all need good housing to live in, and you're doing a great job of it. Just document it so that you don't get yourself caught by a bunch of tenants that try to gang up on you and misrepresent what's actually happening. That's it. We defend your territory. Have a great day.